and the information needed to complete an Asylee adjustment of status application. It is to familiarize you with potential red flags. It is to provide an overview of the law relating to asylum status and a comparison to refugee status. It doesn't explain the other components needed to submit an Asylee adjustment of status package, and it doesn't explain how to conduct an intake for an Asylee adjustment of status application. I'm going to provide you with a quick legal overview. There are two ways that you can apply for asylum status, affirmative or defensive. Affirmative means that you apply directly with USCIS, the Asylum Division. It means that you're not in removal proceedings, and if denied and you have no lawful status, you will be placed in removal proceedings. If denied and you have valid status like FM, tourist visa, or TPS, then you would return to that status. If you are approved, you are granted asylum status. As of September 2018, there are 319,202 pending cases with USCIS. Whenever you see a green link like this means that it's a link to a CIS website or some other type of resource where you can find more information. Now, if you want to apply for asylum defensively, it means that you are already in removal proceedings and the asylum claim is a defense to removal. You're asking for relief from the immigration judge. Also, please be aware that asylum seekers do not have a right to a court-appointed attorney in immigration court. An asylum seeker would need to contact a private attorney or a nonprofit to represent them. The Immigration and Nationality Act, otherwise known as the INA, is where you can find the immigration laws. The definition of an asylee is found in section 208, small a1, which says that any alien who is physically present in the U.S. or who arrives in the United States, whether or not at a designated port of arrival, and including an alien who is brought to the U.S. after having been interdicted in international or U.S. waters. That's an individual who can apply for asylum. So basically anyone physically present to the U.S. or who arrives in the United States. It is limited by INA section 208 small a2, which says that if someone has a safe third country to go to, they cannot apply for asylum. So they cannot be sent, they cannot have access to a safe third country. If there is a time limit, you must apply within the first year of arrival. If you do not, you cannot apply for asylum. This must be your first asylum case. If you have had previous denials of any asylum application, you will not be allowed to apply for asylum. And change conditions, which means that even if you if more than 1 year has elapsed, but you can prove change or extraordinary circumstances that prevented you from applying within that first year of arrival, you can apply for asylum status. And the relevant section of the law is here in this link that I provide. So the conditions for granting asylum are found in INA section 208 small b1. And in general, so the general eligibility is that the Secretary of Homeland Security or the Attorney General may grant asylum to an alien who has applied for asylum in accordance with requirements and procedures established by the Secretary of Homeland Security or the Attorney General. And under this section of the Secretary of Homeland Security or the Attorney General determines that such alien is a refugee within the meaning of section 108 small a 42 big A. And so what that means is if someone applies for asylum at USCIS, it's the Secretary of Homeland Security that makes a decision, right? Or the employees of. And if somebody applies for asylum through the immigration court, then it is the Attorney General, ultimately as the head of the Department of Justice, who makes that decision, or the employees. And then the